Good afternoon, everyone. Welcome to our channel. My name is Ismail Shahtakhtinski, and I'm the principal immigration attorney at IES Law Firm. Thank you for everyone who is joining us. Please hit like, please, if you find it helpful, if you find our videos, live streams helpful, please hit like, please subscribe to our channel, and please spread the information. So as we keep it bi-weekly live stream in our English language channel, we will continue doing so. Today, we decided to do it on Friday at 12:30 p.m. Eastern Standard Time, also known as New York time. We will probably do it, so continue doing it on Fridays at 12:30. So our audience members from abroad, as well as audience members from Western United States, from California, can join us. But we'll see how it goes, and we may switch it back to Thursdays at 7 p.m. or maybe even do, toggle between those two different times so everyone can join us. Those who may be, not able to do it during the lunchtime on Fridays, then can join us on Thursdays. But again, thank you very much, everyone. Welcome for joining us. Thank you for joining us. And today's topic will be on green card holders travel abroad, lawful permanent residents traveling abroad. What are the issues? What are the developments? What you should be careful about? What you should be aware about? What are the changes in the enforcement? How long you can be absent from the United States, and so on. The format of these live streams is that I will talk to you about the topic. I'll explain to you everything I can, and you can also post your questions in the chat section. So once I'm done with my part, then I will answer all of your questions in the chat section. So please do not hesitate to ask any questions you have. It doesn't necessarily have to be related specifically to this topic of today's live stream, but anything related to immigration, you can post your question. I'll do my best to answer. If you are watching this this video after the live stream, you can also post your questions in the comment section, and we will do our best to answer all of the questions. And again, if you find this useful, please hit like. Okay, so green card holders traveling. The first and foremost, I want to make sure that everybody understands that green card, a permanent residency in the United States, is for permanently living in the United States. It is not for easy travel in and out of the country. It does not replace the visa. I mean, in a sense, it does. It allows you to travel, but as long as your permanent residency is in the United States. The issue comes up when sometimes people apply for permanent residency because they may have a U.S. citizen spouse or U.S. citizen child over 21 who is willing to sponsor their parents. And then they apply for easy travel back and forth, but they do not really intend to permanently live in the United States. And that's when most of the time people have issues because they travel too frequently or they are absent for long times. And then each time they return to the US, then they start having problems at the border. So if anyone is applying for a green card for permanent residency, just to be able to travel easily so that you don't have to apply for a visa, think twice, think 3 times, because that can become a headache. You will have to maintain your permanent residency, you have to travel, and there will be issues at the border, even if you travel to the US every 6 months. So regarding the 6 months period for green card holders traveling to the US. Everybody heard of 6 months. There you cannot be absent for more than 6 months, and so on and so forth. There is also 12 months. There is 1 year absence. What is that? And I'll explain it to you. Regarding this, there is a lot of misperception. Some people think that if you enter the US every 6 months, that's it. There will be no questions. You're safe. If you're a green card holder outside of the US, if you enter the United States every 6 months, people believe that they're not going to have any issues, but that's not true. So the way it works is that if you are a permanent resident, as I said, you have to be permanently residing in the US. Anytime you travel outside of the US, there is a question, right? When you return, even if you're absent for 1 day, when you return to the US, the Customs and Border Patrol agent can ask you what was the purpose of your travel. And even if you've been absent for 1 day, and if you answer by saying, oh, because I live in another country, not in the US, you can still lose your permanent residence in the US. You will be deemed to have abandoned your permanent residency. So with the green card, with a permanent residency in the US, with the LPR status, those are all same things. Green card, LPR, which stands for lawful permanent resident, and then permanent residency. That's the same thing. That's basically the green card was permanent resident in the US. So with that, you have to permanently live in the US. You can take brief travels for whatever the purposes are. You can, whether it's business travel or family visit or vacation and so on, you can do so. But if you return from even 1 day travel and at the border, the Customs and Border Patrol officer asks you, what was the purpose of your travel? Why were you absent? And you tell them that I've been absent because I live in another country, then they can take away your permanent residency and give you summons to appear in immigration court in removal proceedings, which is also known as deportation proceedings, where you will have a chance to prove to the judge that despite of what you told the officer, you never abandoned your US US permanent residency. And that becomes a challenge. If you told the officer that you don't live in the US, now how are you going to prove that to the judge? Many people don't understand that the way it works is that if you are entering the United States, even from trips that lasted much less than 6 months, you may still be questioned about the reasons of your absence. If you have been absent for more than 6 months, but less than 12 months, the officer at the border is instructed to ask you questions and to presume that you have abandoned your permanent residency, unless you prove to the officer, you demonstrate to the satisfaction of the officer that despite of your lengthy absence, meaning over 6 months, you still maintained close ties to the United States. What that means is that you have documents to show that despite you being absent for over 6 months during a single trip, you still had your state ID, you have bank account statement, you have property in the US, you pay your taxes, you have tax returns, you have family in the US, family members, you have some kind of commitments in the US, or maybe you have a job in the US, or you have some kind of business in the US. The closer you have ties to the US, the more of those documents you have, the longer you can afford to be absent from the US as a permanent resident and not worry about losing your green card. In fact, anytime you travel, if you're a green card holder outside of the US, we recommend that you carry with you a travel file. That's what we call internally in our law firm. We call it a travel file. So that travel file will contain those documents showing your close ties to the United States. And as I said, most known documents, most well-known ones are your tax returns, your state ID, your credit cards, your bank account statements, any kind of documents showing that you have close ties. I mean, in some circumstances, people don't have those documents. They may have a tax return, but they may not have a state ID. They may not have a bank statement or credit card statement or some kind of transactions, so on, or they may not have family. Then you got to improvise. You got to think of what else demonstrates your intent of permanently living in the US, that you never abandoned your intent. So the length of your absence is just one of the factors that is considered by the officer at the border in deciding whether you abandoned the United States permanent residency or you intended to return and live permanently in the US all along. That's what it is. So the length of absence from the US is one of the factors. As I said, the other factors may be that the officer may ask you a question, what was the purpose of your travel? And you say that I don't live in the US. That can by itself can be enough for them to summon you to appear in immigration court. Now, what if your absence is more than 12 months? Then it's much stronger presumption. It's not absolute presumption, but the officer is instructed to take away your green card, the actual card, and to issue summons, basically a notice, to appear in immigration court in removal proceedings. There is also a lot of misunderstanding that they may not let you inside the United States, and that's not true. They have to let you enter the US because you're still a permanent resident. The officer at the border doesn't have a right, doesn't have the power to take away your permanent residency. The officer at the border can simply question the reason you've been absent for so long, or that you've been so frequently traveling abroad. And if the officer believes that you did abandon permanent residence, that there is sufficient evidence that you abandoned your intent of permanently living in the US, then that officer can take away the actual card, give you a paper or stamp in your passport, and give you a notice to appear in immigration court, where you're invited, summoned to prove to the judge that despite of all your absences, you always intended to live in the US, or despite frequent absences or long absences, or despite of what you said or what you did in another country, then you never abandoned your permanent residence in the US, and you maintained your permanent residence in the United States. Now, that's a big headache. The reason it's a big headache, because during that time, first of all, going to immigration, nobody likes going to courts, especially defending yourself as a defendant. In this case, it's called a respondent, where you're one step away, basically one judge decision away from being ordered removed from the United States, right? Deported. So, as a green card holder, if the judge disagrees that you intended to live in the US despite your lengthy absences or frequent absences, the judge can order your deportation from the United States and strip away your permanent residence in the US. So you don't want to be there. You don't want to end up there. We'll talk about that court process and travel during that time. But the most important part is to try to do what you can preemptively, not to end up in this situation. So what my recommendation is, anytime you travel as a green card holder outside of the US, carry with you a file. That your file should contain a copy of your tax, at least last year's tax return, but preferably tax returns for all these years that you've been permanent resident, even state tax return, IRS tax return copy, any kind of official documents you got from the government, whether it's state government, local government, or federal government. That could be, your state ID, could be anything else, your social security card, any other document you have with your name on it. It could be a business registration, some kind of license, and so on. So put that in the file. Also put in the file any bank statements, if you have bank accounts in the United States. And if you just became a permanent resident, you can do these things. And I always recommend the first thing that you should do as soon as you enter the US, because you never know when you need to travel outside of the US. You should go and get the state ID, open the bank account, open a credit card, and you can carry those credit card statements with you. If you own a property, if you own a car, real estate, make sure to include those documents in that file and carry with you. Those are going to be very useful also. And there is a lot more you can include. As I said, you can be creative and think of other types of evidence. It could be your medical insurance information, your health insurance, your life insurance, any kind of insurance, your car registration, and so on, to show that, hey, I've been absent outside of the US for more than 6 months, but yet, look at these documents. I am US resident. That's where I have property. That's where I have insurance. That's where I have my state ID. That's where I file taxes. And all of that demonstrates that despite your absence, you've always maintained your permanent residence in the US. Don't fool around with it. It's very important, especially now. So under the Trump administration, the enforcement against permanent residents who have been absent from the US for either too long of a time or too frequently. And that's also something many people misunderstand. They think that with the green card, as long as they return within 6 months, that's it, the topic is closed. Nobody's going to question them. No, that's not true. Eventually, it will catch up with you. Eventually, one of the officers is going to stop you, take you to secondary inspection, and ask you, even if you've been absent from the US for 3 months, 4 months, 5 months, less than 6 months, they will eventually start questioning you, and they'll give you warnings. And again, they may take away your green card and issue summons to appear in immigration court to defend against deportation, even though you are a permanent resident. So your green card, your permanent residency, your status as a permanent resident can only be taken by immigration judge or by yourself voluntarily. So what also may happen is if you travel too frequently outside of the US, or if you spend lengthy times outside of the US, the Customs and Border Officer can give you Form I-407, which is a voluntary abandonment of your permanent residence in the US. And they can try to convince you or to push to do under duress, to make you believe that this is good for you, to sign that form. If you are intending to abandon your green card, you're really not truly permanent resident, then you can consider signing it. Maybe instead of having these headaches, having all these troubles, maybe if you abandon and then you get visitor visa and then travel to the US back and forth as a visitor to visit your children, maybe that's better. That's what it's designed for. So that might be a good idea. But in any case, if you have doubts, even if you have a little bit of doubt and inclination that maybe you want to permanently live in the US and so on, do not sign that form. Do not feel pressure that you need to sign that form. You can always do it. You can, even after you enter the US, they call you to immigration court, and then you change your mind and you say, okay, no, that's fine. I'll just voluntarily give up my permanent residency. You can do so later. So the general advice that I will give you is do not sign that form under duress. Do it on your own terms if you decide you don't want to permanently live. You don't want to try maintaining your green card and having these troubles traveling back and forth, and you can resume it. You can apply for a green card again down the road when you make up your mind and when you decide to move permanently to the US. So those are options. You can think about it. Now, there is a very good option if you do want to kind of push your move to the US or take a break from your residence in the US while you're a green card holder because of some kind of commitment, personal matter, family matter, or business, and so on. So that pre-authorization is called a reentry permit. You can apply for reentry permit while you're in the US, and then you can depart from the US while your reentry permit application is pending, with the condition and with my recommendation that you return to the US within 6 months until your reentry permit is approved. But once you get the reentry permit approved, it will give you 2 years of absence from the US without questions about the length of your absence. So what it means is that once you get your reentry permit approved, it gives you 2 years permission to be outside of the United States for 2 years, and nobody will use that absence against you. They cannot call you to immigration court just simply saying because you've been absent from US for 2 years. You can renew that for another 2 years, and then you can keep renewing it annually. We've had some clients who've been absent from the United States for, travel. You still have to travel because if you renew it, you still have to enter the US. But they have, been absent for 5-6 years, meaning they got their green card, whether through diversity visa or through family sponsorship, and then eventually they ended up having to continue their work, their business, or take care of the family matters in their home country, and they just kept kicking the can down the road by applying for that reentry permit and renewing it for 5-6 years. I think the most I had was about 6 years. One individual, they were working for an organization abroad and they had to be absent. So we kept renewing the reentry permit, and eventually he moved to the US. Now, when you have the reentry permit application pending, you can still travel outside of the US, but you don't have the permit approved yet. So you have to be cautious again. You have to return to the US within 6 months or so. But just a copy of the reentry permit application notice itself, the receipt notice, is also going to go into your travel file and will add as additional evidence demonstrating that you're still intending to live in the United States permanently. So reentry permit is exceptionally helpful tool for anyone who is taking frequent travels or who is planning to be absent from the United States for more than 6 months. To be honest with you, I recommend anyone to have reentry. It costs money. It's not free. It's, there are filing fees, substantial filing fees now. There is legal fees involved. So, may cost you about $2,000, $2,500 altogether or so. But it will give you the peace of mind for the next 2 years that if you travel, if you have to leave the US for lengthy travels, you're not going to be having problems simply because of the lengthy absences or frequent travels abroad. So it's always a good idea to apply for that reentry permit. It's always a good idea to carry with you the travel file, no matter how long you are planning to be, because a lot of times people don't know how long they're going to be absent. During the COVID time, some people got stuck abroad for quite some time. Or, over these 19 years of my practice, I've seen so many different things. I've seen individuals get stuck because they have family matters. They have suddenly their, parents get, elderly parents got sick, and now they have to remain there, take care of them, or they have issues within their immediate family, so on. So there are so many different things that can unexpectedly cause someone to be, or somebody gets a job offer while they're, visiting a lucrative business opportunity and then decide to stay there. Of course, they can come to the US, apply for the reentry permit and leave the US, but that's a hassle. That's additional cost for travel and time lost, because for reentry permit, once you apply, you will be scheduled for fingerprinting. You will have a biometrics notice, and you have to be present in the US during the biometrics appointment. So you may have to travel twice if you didn't think ahead and applied for reentry permit ahead of time. So this is about reentry permit. So travel file, we talked about. Let me now go through several scenarios, and I'll tell you, whether someone with a green card can travel or what they can do in these scenarios. And there are many different scenarios, but you can please post any questions you have in the chat section, and I'll do my best to answer within the next 40 minutes or so that we still have left. So the first scenario is asylum-based lawful permanent resident traveling to their home country. So that means somebody who got their green card through asylum and they are traveling to their home country. Will they lose their green card? Can they have problems with asylum? The answer is yes. It's not an absolute loss, immediate loss. It's not a default loss of asylum status or green card, but it will raise significant questions at the time of citizenship, or it may raise questions at the time of re-entry into the US. So, and those questions are that, if you were able to return to your home country as a green card holder, as a permanent resident, then why did you apply for asylum? Why did you first claim that you cannot return to your home country, and then you get asylum and you get a green card, and then you return to your home country? Those two things are contradictory. So you can explain, if you have a good explanation. I had a client who's been to his country 7 times after grant of asylum, but he had a very good explanation, and he was separated from his spouse, his child was there, and it was ethnic-based asylum claim. The government wasn't trying to persecute him, but the society did. And so explanation was that, it's a different thing to live there permanently versus traveling there briefly for a visit. So again, there are possibilities, but, don't take that risk. Don't travel for a vacation to your home country if you got your green card through asylum, because you can lose your green card, you can have your asylum case reopened, and you can be placed in deportation proceedings in immigration court. So the next scenario is lawful permanent resident, again, green card holder, traveling while the green card renewal process is pending. So the green card renewal process is the form I-90, I-90. So let's say your green card is about to expire and you filed for renewal of your green card. The other form, the other type of green card renewal could be form I-751 for those who had 2-year green card conditional based on marriage. So if you got your green card based on marriage with a US citizen, you got 2-year green card, and then after 2 years, you have to file a petition to show that you still live together, you're still in a happy marriage, unless you're divorced and there is a waiver one. But in any case, you have to file this I-751 to renew your green card, to remove the conditions and renew your green card. And during the pendency of that case, can you travel? Or during the pendency of your I-90, renewal of your green card? Because it takes considerable amount of time. It takes about 2 years, 1.5 to 2 years currently to renew your green card. But it expired. Can you still travel with expired green card? Can you still travel while your renewal is pending? The answer is yes, you can, because those renewals you will receive, once you file those renewals, you will receive a receipt, and a receipt will show that your green card is automatically extended. So with expired green card plus that receipt, you still have evidence of your permanent residence in the US. But let's say you are abroad and you've been absent from the United States for quite some time, and your green card expired while you're there. You never filed for renewal. And now you're thinking, should I return to the US? The answer is depends. You can. The first answer is you have to understand. If you're you're lawful permanent resident, if you are a US permanent resident, you remain US permanent resident until you or the immigration judge orders that you're no longer a permanent resident, takes it away. So only immigration judge or you can take your permanent residency away. You voluntarily, or the immigration judge can do so. So even if you're abroad and your green card expired, no matter for how long you've been absent from the US, you still remain as a permanent resident. And you can buy an airplane ticket, board the plane, return to the US. The problem you're going to have is at the border, they will take you to the secondary inspection. They'll question you. They'll try to pressure you to sign in the I-407, the abandonment, which we talked about earlier, which I don't recommend. If you're determined that you didn't abandon your permanent residence in the US, then don't sign that form. But they have to let you into the US, and they will allow you to enter the US, but you will most likely have a court hearing in immigration court where you have to demonstrate that you didn't abandon your permanent residency. So even with the renewal or even with the expired green card, you can still do so. You can still enter the United States. Okay, the next question is, not question, but scenario is, lawful permanent resident who entered but has not received physical card. So what it means is that if you are a green card, let's say you got your immigrant visa successfully through consulate, whether it's for diversity visa or family sponsorship, employment, doesn't matter. So you enter the United States for the first time and you don't have the card yet, because for you to become a lawful permanent resident, you have to first enter the United States as a lawful permanent resident with an immigrant visa if you are coming from abroad, meaning if you didn't go through adjustment of status in the US. Then once you enter the United States and you're in the US, but you don't have the physical card yet because it takes time to arrive in the mail, you left the US. And let's say the card never arrived. What do? Or the card arrived, it's in the mail, and you're over there, the card is here. So typically what we recommend is have it mailed, or your mail checked by someone, a relative, a friend, or someone who can mail it to you by secure mail, something like DHL, FedEx, and so on internationally. Or if you never received your card, or if it's stuck in the mail, you can use your visa stamp in the passport. Because when you went through the consulate, they stamped your form I-551, which is a visa stamp for you to enter the US for the first time as a permanent resident. And on that visa stamp itself, it says that once it's endorsed, meaning once you enter the US and the US Customs and Border Patrol stamps it, that you entered the US with that visa, then it automatically becomes a substitute for your green card for 1 year. So for the next 12 months, you can easily use that as your green card instead of the actual physical card. So the next scenario is frequent short trips abroad, every 1-2 months. So I guess, if we turn it into a question, if I take frequent short trips abroad, will I have a problem as a green card holder? The answer is maybe yes. So if you travel too frequently, then that also raises a question. There is no presumption of abandonment when you re-enter, but it can still raise a question, meaning there is nothing prohibiting the officer from asking a question or giving you troubles at the border because of your frequent travels. So if you have reasons for your frequent travels, gather evidence of it. Whether it's business or brief employment or family matter and so on, gather evidence of it. And again, please put it together in that travel file that you can carry with you, which will help you significantly. You may never use it, but just carry it with you. Okay, so if it becomes an issue, then you can answer. You can use those documents. All right. Green card lost or stolen while abroad. So if your green card is lost and stolen while you're abroad, or even while you're in the US, you're still a permanent resident. Even if your green card expires, you're still a permanent resident. People, again, there's a lot of misunderstanding in this, is that let me give you an analogy. When your passport expires or is lost, do you lose your citizenship? The answer is no, you're still a citizen of this country. So same applies to permanent residence. If you're a permanent resident, your permanent resident status does not expire or does not get lost. It can be taken away by an immigration judge, or you can voluntarily abandon it. So the card itself is like passport evidence of your permanent residency. Again, when you lose your passport or it expires, you don't lose your citizenship. You're still a citizen, but you need some document showing the evidence of your citizenship for travel, international travel. Similarly, green card, that's the role of the green card, is the card itself is evidence of your permanent residency. So it doesn't expire and so on. So if you lost it, there are ways to be able to know, even if you have a copy of it, but you need to coordinate with the CBP first. You need to maybe coordinate with the U.S. consulate abroad, because even though the CBP, the U.S. Border agents, the U.S. immigration authorities at the border, they will figure you out. They'll figure who you are because you have your passport still. They'll find out that you're a permanent resident. But the issue you may have is with the airlines, because the airlines are not instructed to allow you to board the plane flying to the United States unless you prove, you show them evidence of your permanent residency. And by the way, airlines do know that even if your permanent residency expired, you're still a permanent resident. So there is actually a CBP advisory online that to the airlines to notify them that they can board on the plane someone who has expired green card, as long as it's a valid card, but it's just expired. So if you lost your green card, or if it's stolen while you're abroad or even while in the US and you need to travel, there are ways to do it. Okay, LPR traveling while reentry permit is pending. As I mentioned, reentry permit is very helpful, and while it's pending, you can still travel. You can already travel for even, I would say lengthy absences more than 6 months as well, but I don't recommend, because the reentry permit is a big evidence, is a very helpful and substantial evidence that you do intend to maintain your permanent residency even though you're traveling, because you applied for it even before the travel. So that's the requirement. So you have to apply. So you can travel while the reentry permit is pending, but my recommendation is to return within 6 months until the reentry permit is approved. Then you can be absent for a continuous period of time up to 2 years, even without returning to the US. And nobody will question the length of absence. They can still ask you questions, but not about the length of absence. Meaning they can ask, but they cannot use your answers or the reason that you've been absent for 2 years against you. I mean, not the reason, but the fact that you've been absent for such a lengthy time. But in reality, they don't even question when they see the reentry permit. All right. The next question is LPR, lawful permanent resident, green card holder in removal proceedings. So if, let's say, how can green card holder end up in removal proceedings? Meaning in immigration court, in the proceedings, basically where the US government is trying to deport you. What are the situations, one, when a permanent resident can end up in removal proceedings? There are maybe multiple situations, but the most common ones is, number one, lengthy absence from the US, and you're returning at the border, you're crossing the border and re-entering the US, and they question you, why you spent so much time. So what we call LPR status abandonment. That's what we've been talking about all along today, right? So the abandonment could be the one reason why you could end up in removal proceedings. The second one could be criminal activity. If you are a permanent resident, green card holder, and you committed some certain crimes that are usually serious crimes, fraud, there are so many twists and turns. If you have any criminal cases, criminal activities, I'm not talking about traffic, but I'm talking about criminal cases, definitely consult with me, consult with any competent immigration lawyer. That needs to be reviewed. There are so many different twists and turns. Which crime, what kind of outcome, what kind of sentence, which statute makes you removable, meaning deportable or not, even as a permanent resident. So if you have been convicted of crimes, there is a chance to end up in deportation proceedings as a lawful permanent resident. The other part could be, if your case, based on which you became a permanent resident, is being readdressed and reevaluated. So, for example, as I said, an asylee traveling to their home country, coming through the border, returning to the U.S., meaning a permanent resident who got asylum, they may end up in removal proceedings if the government believes that they defrauded the U.S. government by asking asylum, by filing, frivolous asylum application. So all of that can be reconsidered, and that could be end you up in removal proceedings. Or, somebody who went through a process working with a lawyer or interpreter or paralegal who has been involved in fraudulent employment-based or any kind of immigration benefits, and then eventually when those fraudsters get caught, all of the applications where they participated, where the U.S. government finds their fingerprint, reopen those cases. And that's how many permanent residents who got their permanent residence in the past then they end up in removal proceedings. You can end up in removal proceedings and deportation proceedings if at the stage of filing for citizenship. So many people take citizenship applications very lightly. We had a live stream, we had a bunch of videos about citizenship, how complicated it is. Although the form itself looks simple, but the process is very complicated because you have to be very careful what you put there. You have to be very consistent. All of the information you enter has to be consistent with your green card application, the prior applications, all prior visas, and so on. Because citizenship is the stage when the US government has practical last chance to verify everything all over again, and then to give you citizenship of the United States, and that's it. You're now one of us. So at that stage, your entire immigration history is going to be very thoroughly analyzed under a microscope. As long as the officer does what they're supposed to do. Sometimes they don't. Sometimes things fall through cracks. But you shouldn't just put all your bets on that. So citizenship application stage is where many permanent residents, green card holders, end up being burned and end up in deportation proceedings, because at that stage, either because it's true, or maybe because that's what it looks like, because the application was filled out wrong or the information was inconsistent, the US government believes that the basis on which you got your green card were false, such as your marriage maybe was, now they believe that the marriage was fraudulent. Maybe you had an unhappy marriage and then you divorced, and your spouse filed a complaint alleging that this was fraudulent marriage. Now you're going to end up in removal proceedings because of that. It doesn't happen all the time that the government really reacts to those complaints, because a lot of times disgruntled spouse complaints are not taken as seriously. But nowadays, everything can happen. So at the citizenship stage is also another way a permanent resident can end up in removal proceedings and deportation proceedings. So be prepared, plan ahead. Now, the question is, can you travel as a green card holder while in deportation proceedings? The answer is no, unfortunately not. And currently, the deportation proceedings take years. In many cases, most of the judges, it takes years. We have many, asylum cases, we handle a lot of removal proceedings, defense, where we represent our asylum clients in immigration courts and filing cancellation of removal or many other types of applications. And nowadays, we have many judges who schedule their hearings to 2029. So basically 4 years from now is going to be their hearing. During those 4 years, if you're a permanent resident who's placed in removal proceedings, you're stuck here. You cannot leave, because as soon as you leave the US, if you step over the border, you are basically self-deporting. Basically, you are agreeing with the basis and the allegations. Now, there are mechanisms to try to use to close the case administratively or dismiss without prejudice if there is some kind of emergency and so on, and the government, the opposing counsel, may agree to it. There are ways to do it in case of emergencies, but generally you're stuck here in the US. So, that's another reason you should carry that travel file. You should have the reentry permit, is that because if you are in removal proceedings, because of your lengthy absence, unexpected or frequent travels, and you end up in removal proceedings, you should expect that you're going to be stuck here in the US without being able to travel abroad for quite some time. Next scenario is lawful permanent resident who has criminal convictions. So if somebody has a criminal conviction, I touched upon that. Scenario is if you have a criminal conviction, no matter how serious or not serious it is, it will most likely be questioned at the border, and it may end up with serious consequences if the CBP at the border believes that this criminal conviction is serious to warrant your removal, to warrant your loss of permanent residency in the US. So be very cautious if you have, again, criminal convictions. Even if you have criminal charges, make sure you consult with us, contact our law firm. Again, we have been in practice for more than 19 years, and we've dealt with all of these scenarios that I'm describing. I made this outline for this live stream based on, I can describe cases as to each of these scenarios where people ended up in removal proceedings and so on, and those clients then come to us to hire me to represent them. And I see a lot of people doing wrong things that they could have easily prevented in the beginning if they carried with them this travel file, or if they addressed that criminal conviction beforehand, if they had hired an immigration lawyer to handle their naturalization application, rather than listening to friends or family who said, oh, I filled out my own and it worked. I have had so many clients who came to me after being placed in deportation proceedings, after years of being permanent residents in the US, simply because they didn't do the job. They didn't go and consult, at least, with a competent immigration lawyer beforehand. So this is not just theoretical, all of that I'm describing to you. It's all based on the experience, based on what I have seen over these 19 years of my practice. So if you have criminal convictions or even charges, make sure you talk to a competent immigration lawyer. Even traffic offenses like DUI, driving while intoxicated, you still have to carry those records with you. At the border, it can always raise a question, because technically driving while intoxicated in many states, for example, here in Virginia or in New York, those are misdemeanors. So that means it goes from traffic violation, traffic citation, to a criminal violation. All right. And the last scenario that I will describe is LPR, lawful permanent resident, absent for more than 1 year. So if you have been absent from the United States for more than 1 year during a single travel, and now you're contemplating returning to the US, my advice to you is that if you deem that you never abandoned permanent residency, if there were reasons why you were absent, prepare a thorough travel file with all the arguments, evidence of the reasons there, and evidence of your close ties here in the United States. What could be the evidence of the reasons why you got stuck for more than 1 year abroad? Could be, letters, affidavits from friends, family, medical records, whatever it could be, showing why you got stuck there, plus evidence of your ties to the US, as I described previously. I'm not going to go through it all over again, but again, the documents and so on, and evidence from the US showing that you still considered yourself a permanent resident. So take those with you, carry those with you, and then return to the US. You may end up in removal proceedings, but at least you will have a good chance that the officer is not going to issue notice to appear with all that evidence. I've had many clients, as I said, over my practice, the individuals who have been absent from the United States for 5+ years. With thorough preparation, they were able to return to the US without being placed in removal proceedings, even after such lengthy trips. Okay, so my practical tips and reminders, again, Form I-407, do not sign that at the border. Do not sign under pressure that you're voluntarily abandoning permanent residence in the US. Again, over the years of my practice, I've had those who come to me after they did that and then they regretted it. Keep your travel history organized. Make sure that you are, aware of the absences you had. The dates. There is online travel history you can easily retrieve. File taxes as a permanent resident every year, even if you don't live in the United States. Even if you had zero income, I still recommend filing tax return, zero tax return. And even if you missed some tax returns in the past, get a CPA, get a tax accountant. If you need a recommendation, contact us. We will recommend you some. And you they can file tax returns for the past years, and that's fine. That's still evidence that you can carry with you. Keep your address updated in the United States, and keep your travel file with you with all the documents, and keep updating and keep carrying with you. All right. So with that, I'll move to the question and answers. Let's see. Oh, okay. We have a good amount of questions. All right. The first question I will read. Just to thank for all video you've been doing. Thank you for videos. I watched success. I was successful with my refugees case. I've been following you from Canada. Well, thank you very much. Appreciate it. Next question is, I want to say very big thank you for helping me with my green card and finding the citizenship, your kindness, support, and advice. Okay, thank you very much. I appreciate all the nice words from you guys. Thank you. Next question, what are the future prospects for asylum in USA? It's very broad to say. I mean, asylum in the USA is based on the international treaty. Is on the status of refugees, convention on the status of refugees that the United States is signatory to. I don't think there is any hint, but you never know that we may pull out of that treaty. But asylum in the United States, humanitarian law, and it's still being processed. And we get asylums approved over and over throughout. I mean, just last week we had a victory in immigration court. We had asylum interviews granted. Asylum granted through asylum interviews. So it's all going on, and there's a lot of misunderstanding and misinformation about the current changes. There are changes in the law. They're making it difficult. There are precedents that are issued by the Board of Immigration Appeals and by some federal circuit courts that make it difficult to get a grant of asylum. But it is happening, and we do it. We work. We do these kind of things every day. So. I don't think there is much negativity should be around prospects of asylum in USA, even under the current administration. All right, next question. What are the options to invite parents more than 6 months? I don't understand. So meaning options other than permanent residency. So as a visitor, while they're in the US, if there are legitimate reasons, they can file for extension of their stay in the US. So with a visitor visa, they can come and visit you, stay here up to 6 months, but they can always file an extension and get another 6 months, another 6 months, and so on. But the more you file, the first time it's easy, especially for parents, but the more you extend a visitor visa, the harder it becomes than to extend it. Okay, next question is, deeply appreciate your efforts to make these videos for us. Simple explanation and valuable advice. Thank you very much. Thank you for joining. All right, next question is, I am LPR based on asylum. My country, home country passport already expired, and I renewed my passport online. Do you think still I can travel with my green card and my home country passport, renewed one? No, Mohammed, I strongly recommend against it. Technically you can, but you should not. And the reason being is you are availing yourself to the laws of your home country by traveling with their passport. The United States gives you refugee travel document. That's been one of the benefits of applying or granting asylum, having asylum status in the US, and green card through asylum also. You still can get that refugee travel document that is better than passports of many third world countries from which many people get asylum. So if you travel outside of the US using your home country's passport, then number one, that can become a question. I'm not saying it will automatically be a major issue, but it can become a question when you return to the US or when you apply for citizenship down the road. How come you use that country's passport abroad, even though you claim that you're afraid that that country is out to get you, to you're subject to persecution. The other part is the logistical part, or the actual threat, the actual danger you may have, is that if you're in another country with your home country's passport and you end up in trouble and that country has to remove you, deport you, like this is what the United States does, right? When they deport someone, they look at the person's passport with which they entered, and the order of deportation and the implementation of deportation is to that country from which country's passport this individual entered. Now, there are exceptions. There are situations where we can ask to change that. But again, that's basically the challenge you're putting yourself under, the risk you're putting yourself under. If your home country issued, let's say, an international search warrant, Interpol red notice, or whatever that might be, and you're traveling to a third country as that country's citizen, then the third country can extradite you to your home country, and then you're going to have trouble there, right? Because you'll be imprisoned. The United States gives you this refugee travel document, which is the way of the United States announcing to the whole world that you are under the U.S. protection. You're the subject of the U.S. You're a refugee here. Don't send them to his country. We gave him asylum. And that's what your refugee travel document. So the answer is, I strongly recommend against traveling abroad with your own passport. Get a refugee travel document. The fact that you renewed your own passport, it's not as bad as traveling with it, but it still may come up as a question during your citizenship. Okay, next question. If a person has entered through border illegally and got his green card through asylum, will there be any issues for the person to travel outside of the United States? No. Once they got green card, once they got asylum, they already, the issue of entering the United States unlawfully, or with or without inspection, or any unlawful presence in the U.S. is resolved once you get permanent residency. There is this thing that many people don't know. There is this trap. If you got asylum and you got a refugee travel document, but you don't have the green card yet, and you travel outside of the U.S. with that refugee travel document, then unlawful presence ban can still apply to you, meaning you may still be banned from re-entering the United States with your refugee travel document plus asylum if you have been unlawfully present in the U.S. before you granted asylum or before you applied for asylum for 6 months or longer. So if it's more than 1 year, that's 10-year ban. If it's more than 6 months, then it's 3-year ban. So be very careful. If you were granted asylum but don't have the green card yet, even with the refugee travel document, you may be stuck abroad. You may be out of luck. But if you've been granted asylum and you got a green card with a refugee travel document, you can easily travel. All right. Even though you entered unlawfully or without inspection in the past. Next question is, how long is green card renewal taking for Dallas? It's very specific. There is online USCIS. If you type Google USCIS case processing times, it will take you to the USCIS website, and you can indicate there, they show by the field offices and so on. You can put I-90, I-90, and I don't think it's in Dallas. Well, it's Dallas Texas is a service center, so it will be probably Texas Service Center. And you can see, and it changes, but it's not very reliable because the USCIS now posts the case processing status, its times in ranges, and sometimes it's huge, but in reality, based on our practice, we see shorter time. Generally, green card renewals take about, I would say, about 12 to 18 months. All right. The question, all right, how long does the reentry permit take to receive the form that allows you to be absent for 2 years without questions? That usually takes about 18 months, year and a half. So 18 months for the reentry permit processing currently. It fluctuates. It's the longest I've seen now, but in the past it was much shorter. It used to be 3 months and 6 months and so on. So it takes about 18 months. During those 18 months, the receipt notice of the reentry permit will be a big, help in the travel file that the LPR can carry with him or her in and outside of the U.S. together with all the other evidence. But I recommend, after filing, at least within the first 12 months to return to the U.S. one more time during the pendency of the reentry permit, but preferably 6 months until they get the reentry permit, and then they can be absent from the U.S. for continuously for 2 years. Is border crossing a criminal conviction? No, it's not a criminal conviction. To be convicted, you have to be first charged with a crime and then found guilty, and then it will be a criminal conviction. There are federal laws under which crossing the border without inspection is considered a criminal violation, but that's not a conviction, and that's not even a violation in the sense that it reflects negatively on your moral character, and it's not a conviction unless you have been charged officially and you had your day in court and you've been found guilty. That's only when it turns into conviction. Generally, that's not the case. Generally, that's not what they do, but in some circumstances, I've seen cases where the government decided to prosecute the U.S. government for unlawful entry into the U.S. Next question. 4 people who are on parole in USA from Ukraine, even if they already have their reparole and not applying for a new period of parole, are receiving electronic bills to pay the new 1,000 fee. So if they already have reparole and not applying for a new period, they're not receiving. Yeah, unfortunately, we keep receiving those, our clients receive those notices, and a lot of times it's not applicable. Not everything is clear on this yet. We will look into it. I don't have the clear answer for the Ukrainian reparolees who have been already granted reparole. They're not applying for a new parole. My first inclination is to say that no, they should not be receiving that 1,000 notice. What we're talking about, under Trump's big beautiful bill, they also enacted 1,000 fee for parolees. It doesn't apply to some parolees, but most of the paroles it does, even advanced parole. So if you have advanced parole and you're planning to return to the U.S. or travel to the U.S. with advanced parole, travel meaning outside of the U.S. and return, then you should pay that 1,000 fee. Your other option is to abandon your advanced parole application. I see potential for class action, and probably this, like many other things under the Trump administration, is going to be blocked by federal court, because those who filed advanced parole while based on their pending I-485 adjustment of status or their asylum or TPS, whatever that might be, they paid filing fees. They also paid probably some legal fees to do all of this, with the promise of the U.S. government that if you're granted advanced parole, you'll be able to travel outside of the U.S. Basically, what they're doing is now they're retroactively imposing additional $1,000 filing fee, right? So no matter what they call parole fee or what, it's effectively an additional $1,000 retroactively. So they either have to refund all of those advanced parole fees, or this shouldn't be applied to those who previously applied for the parole. They cannot just say that now you have to pay $1,000 to return. I think it's going to be either blocked or there will be class action or so on, and some kind of settlement with the government. Do they need to pay this new fee if no pending reparole? Yeah, unfortunately, Tanya, I don't have the answer now. This is still gray. We just started receiving this notice as well. Can I apply for U.S. citizenship even if I file my tax returns with zero income? Would it count to, is it valid? Yes. So if you really have zero income, then it counts and it's valid. You can apply for citizenship. But if you are, defrauding the U.S. government, then yeah, you may have trouble with that. But zero income, so there are many scenarios when one should file for citizenship, file their taxes with zero tax return, even if they had no income. In some cases, it may be either relief they applied for in immigration court, such as cancellation of removal, or in the context of filing for citizenship, where now the citizenship process got complicated, where now you have to affirmatively prove that you have been a person of good moral character. So in those circumstances, I often recommend, instead of arguing that you didn't have to file tax return and you had no income, instead of arguing that, just get zero tax return filed and provide. Okay, next question. If LPR is absent for 6 months or more, the officer, a U.S. entry, will automatically take away your green card. No, it's not automatic. So as I explained in the beginning, it's not automatic. It's officer is instructed to ask questions and ascertain the purpose of the travel, the reason for lengthy absence, and make their own decision. Just like when in a traffic police, the police stops you for a traffic violation, they have a discretion to, they ask you questions and so on, and they may decide, oh, maybe there was no violation, or maybe they decide that, okay, I'll give you a warning. So the same thing, they can do so at the border. And just like the police, when they give you a traffic citation, they can tell you to appear in court to defend. It doesn't mean you're automatically guilty. Similarly, here at the border, when you are absent from the US for 6 months or more, and you are entering the US, the officer at the border is instructed to ask you questions, ascertain, and then they can give you an equivalent of a traffic ticket and tell you to appear in immigration court, but they still have to let you into the United States. But it's not like traffic ticket in a sense. It's more dangerous because you may end up losing your permanent residence in that court and being deported from the US. So you have to be very carefully prepared for that. All right, but they still have to let you into the US. Next question is, hello, is it possible to make I-485 adjustment of status based on I-140 EB2 employment-based to national interest waiver while person in immigration court asylum master applied during B1 visa 180 days? The answer is yes, it's possible, but not if you, so it's not possible to do, to answer to the question I-485, no longer it's possible. It used to be. There is a Precedent Board of Immigration appeals case, matter of LK, which said that if you filed for an immigration change of status or benefit or asylum during your valid status, but then eventually that change of status took longer and it's not for technical reasons, the USCIS has been processing it, then you could file for adjustment of status and that gap in status is not going to be counted. And that has been argued and successfully argued, and some cases have been approved in the past, but the USCIS now took a position that no, that's not true, that asylum pendency is not a technical issue beyond your control, and that's why it doesn't work. In some cases, I hear anecdotal evidence from some of my colleagues that it worked out, but it's not a good idea. It's very risky because eventually it will catch up with you at the time of citizenship stage, and they will probably reopen the case. My brief advice is that it can be consular processed. So if you got your I-140, your employment-based petition, national interest waiver approved, and you have pending asylum case, and you entered the United States lawfully, so you don't have unlawful presence, and you applied for within 180 days, you can easily file through a national visa center and ask for consular processing. And once you have the consular interview scheduled, then you can apply for advanced parole, and you can even apply for emergency advanced parole at the local USCIS office, which can be done within several weeks. And once done, you would leave the US, go through US consulate, you get your immigrant visa, and you return to the US as a lawful permanent resident, and nobody will question this down the road. So consular processing is what I recommend. All right. Next question is, thank you so much for answering my first question, but some countries do not allow a green card holder with travel document. Unfortunately so, yes. They are not, they don't recognize, they're not signatories to the Convention on the Status of Refugees. And that, from what I know, United Arab Emirates doesn't take the travel document. So refugee travel. So, I mean, that's, that's an argument, good argument that I had no other way. So in that case, but just be safe. Again, you don't want to end up in UAE and have the UAE extradite you to your home country if, they issued international search warrant. But in terms of the losing permanent residency, I think that will be safe because now you have a strong argument that there was no way to use the refugee travel document. Okay, next question. Changing the visa status from B1 to F1. My I-94 ends mid-April. The university gave me my I-20 in January, but classes start in May. If wait time exceeds April, my I-94 will be expired. It is very fact-intensive, very specific technical question. So you do need to schedule a consultation either with me or with other competent immigration lawyer. It's not something that you can get on the forums or YouTube live or videos, quick answers. Do not rely. Let's say if I give you a quick answer and say, yes, it's not an issue. Do you want to rely on this? I don't know all of the details. I mean, other than what you wrote, which I cannot analyze here. So my recommendation is when you have such fact-intensive, when, we're talking about general questions here, you should, for your sake, it's just like as if, imagine I have a medical condition and on the live stream, I ask the doctor, please give me quick diagnosis. What do I have? And I rely on that diagnosis. Then I can die the next day if it was something that was given wrong during the fast. So anyway, my recommendation is, it's not that we're trying to get you to pay and do the consultations. No, it's for you. It's for your protection. It would be even unethical for me to answer this question. There are always issues with the change of status, with I-20 and school start date and so on. You have to be very careful to navigate, maybe talk to the school and so on, to school DSO. There are ways to ask for extension or change status to something else in the interim. So there are many ways to do that. All right, so I think that's all of the questions. We've been a little over 1 hour. Thank you so much, everyone, for joining us. We will continue on our bi-weekly, the bi-weekly, let me see, next will be on the 14th, no, November 21st, will be at 12:30. I think we have a slightly better participation, might be more convenient. So we will do it at 12:30 on November 21, next Friday after next. Again, thank you everyone for joining. Thank you for participating. If you found it useful, please hit like. I see a lot of people are joining. Please, if all of you press like, that would be very helpful to us. And please also subscribe to our channel and also share the channel. Thank you very much. Appreciate it and have a nice day.